I do have an extensive more than 15 years of experience in the field of debt syndication, TV study, IBC and debt restructuring. I'm a chartered accountant and company secretary. So I'm going to moderate the session today. And let me introduce our speaker. Mr. Sumant Batra is the speaker, who is an insolvency lawyer of international repute, social commentator and thought leader. Sumant Batra is a past president of ISRO International, as senior international insolvency consultant to the World Bank Group, International Monetary Fund, and other development institutions. He has worked extensively on policy matters in Africa, Eastern Europe, Middle East, and South Asia. Rated as #1 insolvency lawyer by Legal 500 for many consecutive years, Sumant is recognized by CRR as one of the top 100 restructuring lawyers, the only Indian lawyer with over 20 years of experience in insolvency at global and Indian level. Sumant is the author of Corporate Insolvency, Law and Practice. He is a president of SIPI, a think tank on insolvency. A cultural champion, Sumant is the founder and architect of a number of innovative creative projects to promote Indian heritage, culture, art, and literature. He is also the founder of Tiroba, a boutique museum hotel in the Himalayas. He is the author of the best-selling coffee table book, The Indian, and the biography of late actor Sanjeev Kumar. So I heartily welcome Sumant Batra ji as a speaker for this today webinar. Our next speaker is CA Dr. Gopal Krishna Raju. He is a practicing chartered accountant, registered insolvency professional, and a registered valuer from Chennai. GKR is the tax assurance and restructuring partner of Mrs. K. Gopal Rao and Company, chartered accountant. GKR hails from the family of chartered accountants. His father, mother, younger brother, and wife all are practicing chartered accountant. GKR served consecutive 3 terms of 9 years from 2010 to 2019 as Southern India Regional Council member of the Chartered Accountant of India. GKR have been awarded honorary doctorate in governance of GST in government sector by St. Mother Teresa University, Melbourne, Austria. GKR is the independent director, data bank, and have qualified with distinction the online proficiency self-assessment test conducted by Indian Institution of Corporate Affairs. So I heartily welcome Gopal Krishna Raju ji as a speaker for this webinar. Our next speaker is Sudhir Kaviraj ji, who is an AGM and faculty of State Bank of India. He is a graduate in science and has completed his CAIB and ICWA. He has rich experience in branch manager in several branches. Prior to this assignment, he was in SARS vertical at Corporate Center. He is in credit portfolio since 2010, when he was posted as relationship manager in MCG for 5 years.
Good evening, everyone.
So now I would like to give you a brief about the PPAC insolvency resolution process. Prior to, afterwards, we will ask our speakers to contribute and what their thought process about this PPAC insolvency resolution process. So as a PPAC insolvency resolution process, when we talk about, it relates to MSME, it is applicable on MSME. So looking at the if you're looking at the recent statistics available at Udyam registration portal, there are only 26.42 lakhs MSME which are registered out of 3.3 crores MSME businesses as per the reports of India Brand Equity Foundation. So here, which we need to be get highlighted is the total number of MSMEs business is 6.3 crores, out of which 26.42 lakhs only are being registered as MSMEs. So when we talk about MSMEs, what do you mean by MSMEs? So MSMEs, as per the notification, are those enterprises wherein the maximum investment in plant and machinery or equipment does not exceed 5 crores and it's not and the turnover does not exceed 250 crores. So any enterprises wherein the investment in plant and machinery is less than equal to 5 crores and turnover is less than equal to 250 crores, we can term those enterprises as MSMEs. Now, this pre-pack insolvency resolution process, this has been introduced as per the ordinance which has been issued in the month of April 2021, and on July 28th in the same year, the Lok Sabha passed the Insolvency and Bankruptcy Code Amendment Bill 2021 to pave the way for pre-pack insolvency process. Now the question arises: what is the objective of this pre-pack insolvency resolution process? The ordinance aimed at ensuring continuity of the business of the corporate debtor while efforts are being made to resolve the stress. So the prime objective of this pre-pack insolvency resolution process to ensure continuity of the business of the corporate debtor without any interruption, while efforts are being made to resolve the process and align their cash flow as per align the debt of the company as per the cash flow. Now, corporate debtors classified as MSME are eligible to file an application for pre-pack insolvency resolution process. But the irony is that it excludes other type of MSMEs, including partnership, sole proprietorship, HUF, and other unregistered enterprises. So this limits the number of MSMEs eligible for pre-pack insolvency. Now, the second hardship which we do have upon the implementation of the pre-pack is that this pre-pack insolvency process, under this pre-pack insolvency process, the corporate debtor has to obtain various permissions before initiating the pre-pack insolvency process, namely approval from shareholders, unrelated financial creditors, and the adjudicating authority, that is NCLT. Secondly, if there is no unrelated financial creditors, then permission from operational creditors need to be in place, which is again a very delicate task. The third hardship which can be there upon the implementation of the pre-pack insolvency is that numerous intervention of NCLT is there from time to time. That is, although the pre-pack insolvency process is primarily an out-of-court procedure, the legal framework of pre-pack insolvency is primarily dependent upon the adjudicating authority, that is the National Company Law Tribunal, at every level, from the admission of application to the appointment of insolvency professional to manage the pre-pack, and until the final resolution plan is approved, everything depends upon the NCLT mandate. And we know that how much time is being taken by NCLT in CIRP and liquidation process. Secondly, this pre-PAC insolvency resolution process has been formulated with a view that promoters or debtor in possession, that the promoter, whosoever be the promoter of the company, be there until unless the process has been completed, and he's not being thrown out of his seat the moment pre-PAC insolvency process has been initiated. But we need to appreciate the fact that though the promoter is not being thrown out of his seat once the pre-PAC insolvency process is being commenced, but still there is a high degree of intervention from COC, according to which insolvency professional whoso being appointed as an IRP or RP need to take care of the instructions of the COC, because COC needs to approve the plan and need to ensure that cash flow of the company is not being diverted or siphoning off in any manner. So that also creates a hardship upon the promoter to run the company when the pre-PAC insolvency process is already in place. So the timeline which is proposed under pre-PAC insolvency process is it's around 120 days, and within that 120 days, the insolvency pre-PAC insolvency process needs to be completed. There is no provision for any extension under the rules and regulations of the pre-PAC, but still NCLT, production of sufficient ground, can extend on merit basis. So here we are going to discuss how the flow of pre-PAC is going to be there. In pre-PAC, we need to understand that there should be a minimum default of somewhere around 10 lakhs. If the default is less than 10 lakhs, then pre-PAC cannot be initiated by any MSMEs. There is no threshold limit for higher default, but minimum default ought to be 10 lakhs. pre-PAC may be initiated by the MSME subject to an approval received from the unrelated financial creditors of the MSME, representing not less than 66% in value of the total financial debt due and payable by the MSME to such creditors. It also has to be approved by 75% of the shareholders. So if any company wants to initiate pre-PAC insolvency process, first of all, there need to be a default, and default cannot be less than 10 lakhs. Another point is, whosoever company wants to initiate pre-PAC, that company ought to have 66% voting share from an unrelated financial creditor at company level, so that it can be initiated along with 75% voting share of the shareholders. pre-PAC cannot run parallel to CRP. If the company is already into CRP, then pre-PAC cannot be initiated by the promoters of the MSME. Prior to commencement of pre-PAC under the code, it must be ensured that the MSME is not currently undergoing pre-PAC or has not undergone pre-PAC or CIP in the preceding 3 years. Further, it must be ensured that no order for liquidating the MSME has been passed under the code, and that the MSME is eligible to submit a resolution plan under section 29A of the code. So it need to be understood that once the PRP has been initiated and closed, then for another 3 years, you cannot again initiate the pre-PAC. So there is a limitation upon it. In order to initiate pre-PAC insolvency process, the corporate debtor, that is MSME, is required to file an application with the NCLT after taking 66% vote from the unrelated financial creditors. Thereafter, NCLT may either admit or reject the application for initiation of PRP. PPAC insolvency process shall be deemed to have commenced against the MSME from the date of admission of the application by NCLT, and that admission date is known as pre-packaged insolvency commencement date. The corporate debtor is required to submit a base resolution plan to the resolution professional within 2 days from the pre-packaged insolvency commencement date. The RP must subsequently present such resolution plan to the committee of creditors, and the committee of creditors may then approve the base resolution plan for submission to NCLT. Prior to that, there are various other processes which an RP has to adhere to. After the commencement of the pre-pack insolvency process, the RP has to invite claims from all the creditors by giving a publication in the newspaper. And after inviting of the claims, he need to collate all the claims. And apart from collating the claims, he has to invite base resolution plan from the promoters. And after inviting base resolution plan from the promoters, he need to do due diligence in terms of whether the resolution plan abide all the rules and regulations of the code or not. Once it is being abide, then he can place the resolution plan before the COC. COC has the power to either reject or approve the resolution plan. If the resolution plan is being approved, then it can be placed before the NCLT for final approval. If the resolution plan, if it does not impair any, now the question arises whether RP, resolution professional, can invite EOIs, new EOIs from the open market or not. The answer to that query is that if it does not impair any claim owned by the corporate debtor to its operational creditors, then it is not obligatory on the part of the RP to invite any new EOIs from the open market. So there ought not be any compromise to the operational creditors under the base resolution plan in order to avoid any new EOIs which need to be invited from the open market. If the resolution plan comprises of any compromises to the operational creditors, then the RP has an authority, or with consultation with the COC, new EOIs can be invited from the open market. If COC does not approve the resolution plan, then there is no automatic liquidation in this case. So in that case, the RP has to file an application to the NCLT stating out that a resolution plan has been rejected and pre-pack insolvency resolution plan process need to be terminated accordingly. So this is the brief about the pre-pack resolution process, which I thought of sharing with you all so that it gives you a brief idea about the pre-pack resolution process. Now, I would invite Gopal Krishna Raju ji and seek his view on a matter wherein he can guide us in his thought process how MSMEs as a sector is being benefited from pre-pack insolvency process. So Raju ji, it's over to you.
Yeah. At the outset, let me thank Resurgent India and CACS Sudarshan Kedia, Vice President of Resurgent India, my co-speaker, Mr. Sumant Batra, and Mr. Sudeep Kaviraj for this wonderful session. And also, we have with us more than 50 plus participants across the country who are very much keen on the practice of PIRP, pre-pack insolvency resolution process. We have a panel here, so I will not delve on their domain, but I'll bring before the panel 2 or 3 important facets of pre-pack. Number 1, I wish to share among all of you that in this pre-pack, there is a very interesting point called as declaration. Hope this is visible to all of you. We have 2 declarations to be given by directors, which is form number P7 and P6. P7 is a declaration regarding existence of avoidance transaction. And if you look at the form number 1, which has to be filed in the annexure, in form number 1 annexure, there are close to 13 annexures are there. And one of the annexure is the annexure number 9, declaration regarding the existence of any transaction of the corporate debtor as set out in form number P7. So this is P7. And this is one very good thing that that particular application is clean from. Generally what happens is, why this particular application? Please understand, in a CIRP process, directly the financial creditor or the operational creditor, they make an application. And once that particular condition is satisfied, so there is a default is there and the limit is crossed, date is satisfied, and all this stuff is there, the CIRP gets triggered. And only after that, the new, we call in Tamil called the Mappila, Pudu Mappila. So the new groom will come into play, that is the resolution professional. But here, it is everything is pre-packed. So there is no necessity to go for where the funds gone, where whether there is any malafide intention, whether there is a need for forensic analysis to find out where actually the asset is or money is. So here, they are coming out clean, or otherwise they have to mention what are all the transaction, section, amount involved. So this is an opportunity given. This is I will say this very simple, that in case they have done any misdeeds, this is one particular form which will actually give them an opportunity. I will call them as a second chance to come out clean. And there is no need for a forensic analysis and a forensic report to actually cull out where the money went. This is a very good turning point. And there is one more form number, it is called form number P8. And this form, for the first time, I am seeing this particular form. The form number P8, it is a report of the RP. First time I am seeing. And this is a report which has to be given before the, because generally the after the order is passed, IP takes the avatar of interim resolution professional, and then he takes the avatar of RP, then he will take the avatar of liquidator, and in individual or partnership firm, he will take the avatar of IRP or RP or bankruptcy trustee, or he may take the avatar of authorized representative. So these are all post avatars. IP taking multiple avatars. But IP taking the avatar of an IP itself is form number P8. So meaning, so far order is not passed. But this is one report where, and before the work starts, that means pre-pack itself, a lot of professional work is involved. It is not that only post-pack, after the application is made and an order is received, okay, please go ahead. No, and very, very important role here is the banker's role. Rather than having a training for the insolvency professionals, I will request Resurgent India to train all the bank officials to tell them very clearly that we have a resolution model, which is almost like a one-time settlement model, which gets the court to sanction. I repeat, which gets the court to sanction. So which gets the NCLT sanction. And only thing that is required for the banks, financial institution, is an open mind and a will to actually resolve. And if these two things are there, and the role of insolvency professionals is very, very critical. Please look at this this particular form where it says, I will put my name here, Gopal Krishna Raju, proposed for appointment of RP of say ABC, some company or whatever it is, in respect of a pre-packed insolvency resolution process of, okay, and hereby declare and affirm. Please, this word is not that simple. It is not true and fair. I am declaring. I am declaring and affirming that I have sought and obtained all the information and explanations. I have examined the relevant documents and the status, and I confirm that they are a MSME. So that means there is one more form I will show you in form number 1. Whether they have to get themselves registered as a Udyam registration number they have to give, or without a Udyam registration number also they will be eligible for. Actually, they will be eligible even without a Udyam registration, if they satisfy the turnover as well as the investment criteria. But it is worthwhile to, it is advisable to have a Udyam registration, because in that form number, they only mention whether Udyam registration number is there or they have satisfied the conditions. It's very interesting. So these are the things which the insolvency professional has to declare and affirm. And I hereby confirm. It is not audit. Audit is giving only opinion. It is I am confirming, which is beyond audit. Maybe audit fees is whatever rupees, you can multiply into 3x or 4x. This involves that much of homework. And the CD has not undergone pre-pack before. My good friend Sudarshan Kedia was referring that for 36 months, once they have done a pre-pack, for 36 months, they cannot again come back to NCLT. My lord, I want to pre-pack again. No, it is not possible. The CD is not undergoing the CIRP. No liquidation order has been passed. Majority of the director have made a declaration P6. This declaration is very, very sensitive declaration. This is 2 declaration they have to give. Meaning they have to declare themselves that I am a very good person, I am a good boy, I am a good boy, I am a good boy. If I am not a good boy, then tell to what extent I am a bad boy. So these are all the transactions I have done, and I am supposed to actually come out clean. Then I will just, sorry for the interruption. Then we have the creditors of corporate debtor representing the 66 2/3% that have approved the proposal for appointment of RP. Okay. And the creditors of corporate debtor of 66 2/3% have approved the proposal initiation of pre-pack. And the amount of default incurred is within the limit notified. That is what you call it as about 10 lakhs. That is a minimum limit. Okay. And I've examined the base resolution plan and it complies with the section 56 of the code. So this is the, and my lord only goes by this report of IP. My lord goes by the report of the IP, declaration of the existence of avoidance transaction in P7 and P6. So he will only do a test check. I mean, he will only do a checklist and register. My lord will ask register what happened, whether annexure 1 is there, yes. Annexure 2 is there, yes. 3, 4, 5, 10, 13 is there, okay. Then anything else you want to, you have any observation? No. Then you will order. And that is what we have got an order of NCLT Ahmedabad branch last year. In September 2021, we have got GCCL Infrastructure and Projects Limited. Friends, I'll wait for my other panelists to also share some few views and then I'll come back again. Thank you very much.
Thank you, Gopalji. Now I would like to invite Suman Batra ji. Welcome, sir. Welcome.
Thank you so much.
Yeah. So, sir, we would like to understand whether this under this pre-pack insolvency resolution process, when we do prepare base resolution plan, whether financial creditors can take haircut or convert their part exposure into equity.
Yes, of course. So the answer is very simple. Yes, because the regulations that IBBI has framed pre-pack very clearly provide the flexibility or on how the resolution plan may be prepared is quite akin to what you have in the CIRP process for the corporate debtors. So by and large the same, barring a couple of provisions which you may find to be a little different. And clearly, therefore, in clause K of this regulation, there is an enabling provision where equity may be issued in lieu of a debt that may be due, which obviously is a very standard global practice and is any which ways something which the parties have to agree mutually, where in particular the lenders have to agree that they are willing to convert a part of their debt or entire debt or a substantial part of their debt into equity. And I think that is inherent to any resolution because if you don't have that kind of flexibility, we may not really have much resolutions, in particular in the pre-packs. But of course, in practical terms, I'm not too sure, other than the funders who are venture capitalists or private equity funds who may have also extended debt to the debtor, I do not really see whether the large banks would be willing to take equity as a risk, largely because the value of equity in SMEs is largely, not in all the cases in the MSMEs, may not really be as attractive. And the risk, therefore, may be higher. The valuations also may not be very significant. But again, I mean, we are nobody to talk really about that because that will depend on the facts and circumstances of each case. But to answer your question more specifically, yes, it can be done.
So whether the scenario changes if the company is being listed or unlisted in any way?
No, not really. It's again entirely on the parties, but I would believe that when a pre-pack is happening, we do have a situation because this is a debtor in possession concept. When there's a debtor in possession concept, you would also be governed by the insider trading issues because this is not an insolvency professional managing the affairs of the company in that sense. While the debtors, of course, may not be managing the affairs only or exclusively, but they are also there as a part of the management. They have access to information. They are privy to a lot of decision making, and therefore, if it is a listed company where a resolution plan is being done and where equities have to be allotted, where these parts have to be done, it will obviously be also be dictated by the various provisions of the SEBI Act, which require transparency, disclosures, and also restrictions in terms of insider trading and taking advantage of any information that you may be privy to, which may give you an advantage. So that would be a bit of a tricky part, and what that will have to be dealt with will have to be seen in a given case.
Great. So my next query to you, sir, is that whether 120 days timeline for completion of pre-pack is a mandatory clause or recommendatory clause? Well,
it's directory, I would say. It's not really a recommended clause, I would say, or recommendatory clause. It's a directory clause. It cannot be read to be as mandatory, which means that there's an ipso facto clause that in the event 120 days expire, that it will lead to termination of the CIRP or the pre-pack process, or the proceedings will drop dead. I mean, that is not how this section reads. So therefore, it has to be read as a directory, and that is how the Honorable Supreme Court also interpreted the provisions which in the CRP process, which require that the NCLT shall decide the Section 7, 9, Section 7, 10, Section 7, 9, 10 applications within a period of 14 days. The Honorable Supreme Court held that right in 2017 itself, that court cannot be directed to decide in a particular period of time. They are only directory, and they will have to serve as a guidance. But yes, at the same point of time, it is expected that they are completed within a particular period of time. And we all know that even SR judgment, Justice Nariman said that, yes, of course, we have to maintain the sanctity of the time. We have to honor the time commitment. But at the same point of time, you can't say that it is mandatory. And they struck off the word mandatory that was intended in Section 12A, Section 12. So, when it was increased, as you know, to 330 days. So I would also read it in the same spirit, while it may not be mandatory. And in a given case, the court may be able to extend the timelines. But at the same point of time, 120 should be seen as sacrosanct by all the parties, all the stakeholders, and a serious and a sincere endeavor should be made to try and complete this in 120 days. And I think in the context of SMEs in particular, and also more particularly in the case of pre-packs, 120 days is also a very long time in my because usually you would put the cake for baking in the oven even before you go to the lenders to obtain their approval on the IRP, as well as on the on the plan, the basic plan that you put together for their pre-approval before even filing the petition. You would therefore make that effort by applying your mind, hiring somebody, getting into place a plan which would they can be sold to the lenders. And once the lenders have given their in-principle approval to the basic plan, and then that is rolled into a process through the IBC, I don't really see why it should take even more than 90 days. In a given case, it may take more, but not in the case of SMEs. Because if you take longer than that, I don't think the value would survive in the MSME, because the depreciation in the value, the downgrading in the value will happen very rapidly. And also because the dependence on the vendors of the SMEs is very unique. So if you are someone who is supplying steering wheels to Maruti, the Maruti would not wait for you for 120, 40, 50 days if you're an SME. If somebody has the same die and somebody can produce the same quality steering wheel and give it to them, because they can't stop their production for that matter, right? So this is therefore very, very important that the timelines are honored and are actually perceived as mandatory, even though the law cannot really say so. In US, there are instances where even large enterprise pre-packs have happened in 48 hours. If you do all your homework, if everybody's on board, all the law is complied with, you have, Section 30, subsection 2, all the compliances of law in place, the regulations compliance in place, the court should normally not take too long, because you've reached that stage only after you built a consensus, you have everybody in place. But we do know that where an SMA may have other stakeholders, large clients, and other operational creditors, they may actually come and file objections. I mean, you can't really preclude anybody or prevent or prohibit anybody from filing it. The only thing is that the courts should, and it's expected that the NCLTs will tend to be less intrusive in the case of pre-packs, because that is the very purpose. And once the plan has been approved by the lenders, then they should look at very microscopically only on the limited issues, which of course Supreme Court has said repeatedly, also in the context of CRP for the competitors.
So, sir, in continuation to this query only, as you being aware of that only, although 9 months has been passed out after initiation of this pre-pack, so how successful is this mechanism? Do we have any success stories?
We haven't really. I mean, there are a few applications filed, but of course, those applications are for initiation. We haven't really seen any mature so far. Now, I mean, since you asked that question, I have to say that I have strong views on the way the pre-pack has been designed. I mean, a very well-intended legislation or amendment. I think the very objective and purpose of it is diluted by making it as complex as it has been, both on the statute book as well as in the regulations. It was never really meant to be as comprehensive, as complex, requiring so many stages of approvals, ifs and buts, and things like that. I mean, I would say that if you are opening so many windows which require, in fact, which even enable the IRP to inform the COC, and if the debtors are not cooperating or they have not provided right information, they can actually terminate that process and a regular CRP can be started. Or where the plan doesn't meet their expectations, they can invite a competitive bid, and it's a Swiss process starts. And there are other uncertainties as well. Now, while I do understand that if the plan doesn't go through, you need to have a plan B in place in order to make sure that the proceedings are culminated into something more affirmative, or at least to a logical conclusion, if not into a successful resolution of the whole proceeding. But the very purpose of the pre-pack is inherently that it would only be invoked in those cases where there is no trust deficit between the lenders and the promoters, number one, or where the trust deficit existed that can be bridged by the debtor taking appropriate steps. Invariably, it would be where the debtor brings on board an investor, or is able to demonstrate to the lenders even before initiating that if such and such measures are taken, and there is a finality to it and a seal of approval by the NCLT, I would be able to honor my commitments of debt to you, revive the company, and have enough cash flow to honor my commitments if I'm not paying outright. Right? Now, if that is not there, lenders would not make even the first move. Right? They would not just give you your basic plan and approval just for the heck of it, because even to give approval for that, they will have to go through their competent authority. So competent authority at that point in time only will give you a complete signal that while we are approving your basic plan, but as far as the commercials are concerned, we do not agree with that, but we do agree with your large contours of your plan. Having said that, it doesn't mean that it is a final approval. You can't treat it as a final approval, but they would give an indication that no, we would expect to take not more than 40% haircut, or blah, blah, blah. Or if the proposal are based, if the basic plan is presented to the lenders and it says 80% I'll convert debt, 80% debt into equity and only 20 I'll pay, and I'll pay over a period of time, they would even give an approval, right? They would ask them to amend their basic approval and bring it again. They will say, okay, fine, you bring it, but we are still approving it subject to discussion and final approval on 8, 10, 5 items, right? But the commercials would be agreed, or at least the broad contours of the parameters would be agreed. Now, once that has been done, why would you want to make the process disruptive? Unless, of course, the debtor itself retracts from the proposal that it has given. At the same point, the lenders should also not be allowed to detract from the proposal that they have approved as a base in the basic plan, as far as the commercial is concerned, unless, of course, they kept some disclaimers and they're only operating within the realm of those disclaimers or qualifications in that sense. And therefore, I believe that all these ifs and buts, various processes, approvals, stages, is quite detrimental to the pre-pack process and the very objective and intent behind it. I do feel that it has to be left entirely to the parties to negotiate. And once they have negotiated and agreed on something, they should just come to the NCLT for the final stamp of approval to make it binding on the parties. And the NCLT only satisfy if Section 32 is done or not, and not go into any other aspect. And this should be more strictly applied here in the SME's case, because the lifespan of SMEs, their their breathing levels, their oxygen levels are very different from the corporate data, right? An ordinary large enterprise. So from that point of view, I do feel that there are various dissuading provisions in the pre-pack scheme. The second point that I'd like to make is that I haven't really seen the same level of conviction amongst the government machinery also to make pre-pack work the same way they actually made the earlier corporate data process rollout, insolvency provisions rollout. Now, this could be also because the signals from the market has not been very good in that sense. I feel that government should give it a chance on as is where is basis. Once the law has been done, it's all our duty to make sure that it works well, and we should make an effort, a genuine, sincere, honest effort. That effort should be made, and in that process, the government should do more stimulation. They should do more awareness exercise. They should handhold the SMEs, the MSME association. They should get together with them, hold seminars, workshops, prepare templates of basic resolution plans, templates of various other provisions, have a cadre of IPs who are willing to work for SMEs on a smaller fee and all that aspect. And then I think we might see some positive results.
Thank you, sir. Thank you. Thank you for enlightening us with your views, sir. Now I will move to Mr. Sudeep Kaviraj. Sudeep ji, are you there?
Sure.
Yeah. So, sir, would like to ascertain from your side and your view, sir, what your view is about the pre-pack insolvency and what pros and cons you see when any proposal for pre-pack is coming to you. So, over to you, sir.
Thank you very much, Sudarshan ji, and it's a privilege to be here. And good evening, everyone. Good evening, our other panelists here. From the very beginning, let me state my personal opinion, definitely. And being in Training Institute, that is BSCRM, one of the Apex Training Institute of India, I'll provide my personal view only here. And with that, I'll take the cue from our Mr. Raju, regarding training of bank officials. Definitely look into that one, so that we have the people in that moral and that helm of things, that yes, they can go forward with a new system of PPIRP, as we call it, or maybe PIRP, pre-package insolvency process. So before going to that one of basic of your pros and cons of PPIRP, and with that, whether the proposals is coming to us, as I've told you, we are being in Apex Training Institute. Maybe this is not coming to us directly, but yes, flow will be there in the months to come. Now, going ahead with, if you compare with CIRP, or for that matter, IRP or fresh Apple systems, or whatever you say, or the other ways we have in the personal insolvency, as you find that this is for the corporates, right? And it is not for the individuals or something, partnerships like that. So definitely, when this level of amount has come down, from 1 crore to 10 lakhs, definitely MSMEs are looking at it, so that there can be some way as to how to take that opportunity going forward for resolution of the stressed one, whatever it is. And as our panelist has just said beforehand, that yes, when you have already a base plan, with that you are working upon, it will be definitely a good opportunity for both the sides, all the stakeholders, to have a very, whatever the final things that has been taken care of before the application is moved. And definitely within 90 days, it is maybe possible to have a threshold thing of a resolution, first of all. Secondly, as from that point of view, where we find that yes, it's previously we had a thing where creditors were in control, and maybe debtors were thinking that no, it was a change of management, something like that, to IRP or RP. So now you have the people there itself in the helm of affairs to take forward the resolution process, take forward the base plan. And naturally, there with the going concern concept, maybe it is a wise thinking that going forward we look into that one, that yes, definitely something can be done, right? And the stakeholders are there itself in the process, all the stakeholders, whether operational creditor, whether financial creditors, whether the corporate debtor, everyone is present in that scenario. And that is a very good opportunity for everyone of us, first of all. Secondly, in this pandemic, where in COVID-19 we have seen that the things were stalled for some reason or other, naturally, we had to think of how to go forward with the resolution process, where maybe prospective buyers are not present, maybe not because of the scenario. So naturally, the corporate debtors own, the zeal itself will work for us, for everyone in this economy, to see that yes, definitely something can come out of this, relatively new and something in a different way that has been done. As our Mr. Batra was also speaking about that, going forward, though it is not, maybe some directions are there, okay, maybe directive way, but may not be mandatory or somewhat mandatory or whatever it is. And this time frame on 90 days or maybe 120 days, that we reflect that yes, what government or what stakeholders are requiring to have some resolution in a very quick manner. As you've seen in CIRP, maybe the average time frame within which you resolve the things, that is something, maybe that is a 330, 340, 350, that is this. And for these small units, which is in a major plank of our Indian economy, you have a process whereby you can resolve the thing within 90 days, 120 days. Because you have the base plan where you have already thought of the situation, how to go forward, whether is a compromise, whether haircut is needed to be taken, whatever is, you have the taken decision. So let's go forward and see whether it can be done in the process itself. So that is the way, maybe I feel, yes, it is a good thing that has come during this pandemic that we had. And maybe in the months to come, we are going to see a lot more proposals to come. Thank you very much. Yes, please.
Mr. Kedia, you're on mute.
Thank you, sir. Thank you. Sir, we have received one question wherein it has been asked that what are the circumstances under which a new EOI from the open market can be invited. So I would like Suman Batra ji to answer this, if convenient to you, sir. You're mute, sir. You're mute.
Sorry, yes. Yeah. I mean, I don't remember the exact provisions. I didn't really, honestly, I just got out of the JP hearing and walked into this conference. It went on till about 4:30, 4:45, and then there was a plan approval application I did. I came in here. But if I remember correctly, when we were framing the regulations and we were discussing them, and I also made the initial presentations, basis that what was agreed was inherently, in principle, and that is how you might have to interpret the various provisions. That one, of course, where the resolution, where the debtor itself, the debtor in possession itself decides that it can no longer continue to pursue it. And of course, which means that if there is a change in circumstance or where it fails to persuade the lenders whose approval is required that such terms are acceptable or unacceptable to them, then of course in that event he will communicate, and then at that stage you will shift gears and the COC will decide that let's go through the process of public invitation. The second would be where it is found that actually the promoters were taking you for a ride. And so therefore this is not a voluntary act, but an involuntary act, where the RP brings to the knowledge of the committee of creditors that I've come to know that the information that was provided to me in preparing the IM, or the information that was provided to me in the terms of settlement of claims, or how much are the creditors, debtors, all that information is incorrect, and it appears to me that it was consciously, knowingly provided that way, and therefore the intent of the debtor is not clean, because you're giving him the debtor an advantage by allowing him to negotiate directly with the lenders rather than running through the process of the CIRP. So in that case also you would, the COC will say no, ask the RP to move an application that we are shifting gears. And the third ground, if I remember correctly, is where I think the resolution plan submitted by them fails to meet their expectations commercially. then they may invite fresh applications. But that, of course, doesn't mean that the debtor goes out of the picture at that stage. The debtor remains in the fray, but there has to be a competitive process. But the point I'm making is there are two instances where the debtor goes out altogether. And of course, if it, I don't even, I mean, if they have been debarred to continue in the process, then they would obviously not be allowed to participate again through a competitive process. That is what the intention would be. But having said that, will have to be seen in law whether they are disqualified or not. Now, so the two acts are voluntary and involuntary in the hands of the COC. The rest is more a process driven by the statutory provisions and the regulations, where because of the financial aspects, there is a need felt to invite other parties to submit their plans. And then, of course, there has to be a competition. And the invitation, the plans that are received pursuant to the invitation cannot be lower than the amount which the promoter had given. And I'm simplifying it for the purpose of our audience. But of course, if you get into the nuts and bolts and the exact language, you could actually split it into 3 or 4 situations. But broadly, these would be the situations. Now, the sum of it, if I may say, what is the intent behind it, is that it could be possible that during the lifespan of the pre-pack, there may come a stage where the lenders realize that they're not making progress with the debtor, and they don't want to lose any further time, and they may therefore, decide that they just want to go ahead, right? But of course, lenders still continues to have a right to meet that offer which may comes in, because the whole idea of pre-pack is that you give an opportunity to the debtor. Because an MSME is something where the intellectual property is largely held by the individuals who run the MSMEs. They are the ones, the human resource are the intellectual property. There are very few. Even you have 10 people working, family members and others, they are the ones who constitute the intellectual property. And if they go out, it's hard for a new person to come in and manage an MSME, which basically is governed more by the interpersonal relationships, including with the relationships that they have with the lenders. So, at the same point of time, what the pre-pack does propose and suppose is that if the debtor is trying to play smart, it is trying to mislead, it hasn't come with clean hands, and it continues not to mend its ways. It is shortchanging the whole process, doesn't have the intent, is misleading, then the lenders can also decide. But of course, the only thing is that in such a situation, I do see that the lender would invariably challenge the decision, and he will say, you're causing a stigma on me. You prove that this was wrong, or because a lot of these allegations could be subjective. It could be RP's view or COC view against the debtor, and somebody may have to ultimately determine as a court what is the truth, which may be a derailing process. But I don't really see any MSME actually really getting at that confrontation, because they have to operate in the same market. They won't really want to take a confrontation with the lenders. They won't really want to sort of create that acrimony, in the system, because they know that the lender will then come after them, where they get personal guarantees and others. So I do hope that the pre-pack is actually, used in the right spirit, both bona fide by the promoters, and also the lenders also view it from a less stringent process and approval process as they would have in the other cases in this year.
Thank you, sir. Thank you. So one more last question would like to entertain. The last question is that in this pre-pack, how the bank do provisioning under the IRAC norms. So this question would like to be, I would like request Sudeep sir to answer whether provisioning under IRAC norms, how it is being taken care of under pre-pack insolvency.
To come to that point straight away, I'll just have a detour of that one. First of all, as you know, in the provisioning factor for the IRAC, all accounts are subject to provisioning, whether it is standard or substandard or doubtful, whatever it is. For such a standard, you have minuscule provisioning, maybe 0.25, 0.40 like that. But for the other part, you going forward in the substandard part, you have a huge, raising of the provision being benchmark, maybe 15%, 25%, depending on the security and the stage of the account post NPA. So that is going forward that way. Now, in the provisioning sector also, you have another year of 7 June 2019 circular of RBI regarding the, you call it mother circular for the restructuring, everything, whatever it is, that if you cannot resolve that because of default, you need to have a provision of 20%, 15%, 35%, and you get back that provision, also write back the provision depending on the circumstances, whether you could have that specified period, monitoring period, all these things. So prepack also maybe will be subject to all this framework. You have a provisioning network, provisioning system, depending on the circumstance where the account lies, how going forward, what is going to happen. All these things taken together, the case to case basis, you will have a provisioning factor. So with that, I'd like to stop here itself.
Thank you, sir. Thank you. So due to constraint of time, we are unable to take back other queries which we do have. So I would request all the participants to mail across their queries, and we will try our level best to get it answered back accordingly. And with this, I would like to thank all my speakers who took their time and enlightened us, enlightened the audience also. And with this, I close this webinar. Thank you, sir. Thank you. Thank you.
Thank you.
Thank you, sir. Thank you.
Yes, sir.
Thank you. Thank you very much.
Thank you, sir.
Thank you, everyone.
Thank you, sir. Thank you.
Thank you, Kaviraj ji.
Thank you. Thank you, Mr.